Hi, thank you for tuning in. This is the establishing custody discussion for the Orleans Civil District Court and the 24th Judicial District Court. Today, we're going to go over the initial steps to initiating an action for establishing custody, and we'll go through deeper details as to what exactly that means for those who are representing themselves in court. My name is Kathleen Lejean. I am the managing attorney for volunteer engagement at the Pro Bono Project. I recruit and train volunteers to assist those representing themselves with court-approved materials provided at the help centers that are at the court. Presently, today's date is June 25th, 2020. And so since we're in the pandemic, we have been pausing those help centers. So we hope you find this video helpful. If you're in need of additional questions, you're welcome to visit our website at probono-no.org. There you'll find self-help resource center materials. We have a self-help at probono-no.org email address for specific questions. You can call us at 504-581-4043 and give us a call. We'll be able to connect with you with volunteers who are still assisting individuals virtually. And we want to thank the Louisiana Bar Foundation for funding our programming at these locations. For resources on the information that we're going to be discussing today, we recommend visiting the louisianalawhelp.org website. Louisiana Law Help has a great deal of resources on information, more than just custody. It's divorces, wills, housing, tenant issues, landlord issues. So definitely check that out. We also, before you ever proceed in a court action, we're going to refer you to the Louisiana State Bar Association. There they have the membership directory to determine attorneys who are in good standing. They also have a new modest means panel to work with people who are low income. And they also have resources such as free legal answers where you can ask a question and volunteers will also respond to that way. So we definitely check out lsba.org. But to get you started, if you've decided to represent yourself in your custody hearing, the forms will be available on the different court websites. So for Orleans Civil District Court, you'll go to their form site and look for the Self-Help Resource Center documents. For the 24th Judicial District Court, go to the court website. Now, this is not the clerk's website, the court's actual website. Look for Domestic Self-Help Desk forms, and there you'll find petition to establish custody. I have my petition printed out here. We're going to be doing this on legal paper. That's 8.5 by 14. And we're just going to walk through it. So the first most asked questions with those representing themselves is actually the header. The header is going to be what they use in their online docket master. So it's going to be the petitioner. This is the one initiating the action, and the defendant. You, at the time of filing with the clerk's office, you will pay, and they will give you a number at that time. When you have that number, you'll also receive a letter which will correlate to the judge who will be handling the matter. The header is important because it will always remain the same over the course of the custody. So this is establishing custody. This will be the first filing. So if down the road you want to modify or hold someone in contempt for failing to comply with the judgment custody, then you would still say petitioner versus defendant, case number, that letter, but you would be the mover. So defendant, you may be filing, it may not seem natural, but that's the way that the header is set. That's the case number. The next topic that the document will go into is a term called jurisdiction. In law, you have to make sure that the court is the proper venue and that the court has jurisdiction over the individual to make the judgment have authority. It's also called null. If it's not the right jurisdiction, you'll have a null judgment, which means you paid the money for filing and it has no effect in law. So the jurisdiction in most cases is where the plaintiff resides or where the defendant resides. But in a custody issue, it's also where the child resides. So again, we cannot advise you at the self-help centers. Our program is only, as volunteers, we're only able to provide you information only and procedural information. We do not practice before this tribunal, so we are not necessarily the ones to confirm what would be the proper jurisdiction for your case matter. The one thing we can inform you of is that if the child is a resident of Orleans Parish and both of those parties are there, then this court has provided resources to assist you to represent yourself in that custody issue. Any legal questions outside of what that the court has allowed us to assist you with, you'll have to seek legal advice. So in the hypothetical we're going to move forward with today, everyone resides in Orleans Parish. That's the plaintiff, defendant, and the child. So I'm going to detail that Kathleen Lejeune is the petitioner. She is seeking custody of her daughter with John Lejeune. The child's name will be Jane, and we'll include her birth date here. For Orleans Parish, this is for biological parents. They also have a document for third parties and for grandparents. For the 24th Judicial District Court, you only have self-help materials for biological parents only. So if you are a third party or a grandparent, you'll need to seek legal counsel to proceed in that court. So once we've established that we have the jurisdiction and that we're here to discuss a child that was born of those two parties, we then need to conform what would be in the best interest of Jane for custody. And those best interest determinators, there are 14 factors. This is legislation that was passed by the Louisiana state. So that information is going to be available on the louisianalawhelp.org. It's important to understand and know those 14 factors, because once you file this petition to establish custody, you're going to get a court date. We'll talk about that in a bit, but they're going to send you a packet in the mail, and that packet is going to be about 14 to 15 pages where you're going to detail exactly why you feel that this is in the best interest of the child, exactly what the custody will be. The initial petition is just to give the defendant notice as to what kind of custody you'll be seeking. So on our second page of the petition, we go into further detail as to whether or not we want joint custody or sole custody. This information will be posted in the docket master, so it will be public. This is the information that the defendant will be served with, and this is what the defendant is being put on notice to prepare for the hearing. So anything that you're going to list, any argument you're going to want to make, you're going to want to include on this initial petition. Otherwise, when you get to the hearing, if the defendant wasn't put on notice that the discussion would be occurring, you're going to have to set yet another hearing date. So that would be including, for example, if you wanted to relocate the child, there was some other legal standard that you need, you're going to make sure this document is what we have been provided by the court to inform the public for its use. If there is a legal argument that this document cannot cover, you may need to contact an attorney to receive advice as to what those other filings may require. So again, we're only providing you procedural information to access to the hearing. So just note that anything that you post on here will be made public as well. So the first option is that the petitioner is seeking for custodial periods to be shared and for one of the parents to be domiciliary. Domiciliary is another term in law which essentially provides one of the parents the right to sign documents, enroll them in school, as well as do medical needs. But that domiciliary parent has to have mediated the issue with the other parent. So what that means is that the domiciliary parent has a heightened level of standard to the relationship between Kathleen, John, and Jane. The domiciliary parent will be required to communicate if there's any disagreement with how the child is going to, like for school, and for example, they may need to do some additional work in order to place the child in that institution. Otherwise, you could be in contempt of your custody arrangement, and there may be a need for a future hearing. So we're going to say how we want the visitation to be joint, or we're going to say that we want sole custody and how visitation with the other parent will be coordinated. Will it be supervised? Do you not want them to have any visitation? And then you have a space to say why you think that's in the best interest of Jane. Well, it's in the best interest of Jane for sole custody because ... You're going to detail so the defendant can prepare for an argument at the time of the hearing to basically to argue why they don't think that you should have sole custody. So that's on the second page. And again, this is only to initiate the action. When you get the packet in the mail, that's when you're going to get into more details as to holidays and if you want summers or every other week. And additionally, this isn't necessarily exactly what the result's going to be. But the next point is that you have to file this in the court of your jurisdiction, so Orleans. So we're going to have to pay to file it. You can pay with whatever standard. You will check the clerk's site for whether or not they take cash, credit, check. But at a certain point, if we all as a society have the right to access the court, that doesn't mean we can afford it on the days that we need it. So the court has an operation called informa pauperis document. That's a legal term to inform the court that you are in a pauper status and you cannot afford the filing fee to initiate the action, that you will need to either make payments over the course of the hearing or that you need all of the costs associated to be cast upon the defendant. So what we have is that the petitioner be allowed to file an informa pauperis document, which will detail all of the income and all of the expenses of the plaintiff, and that we pray that the court accepts that you're within the federal poverty guidelines. We're not sure what the actual reason, what sort of, I guess, grid that the court is using to determine like who can have their fees deferred versus who can't. But we do believe it goes along the federal poverty guidelines. So you may want to look up what that is for your year. So if you're, for example, a family of one and you're approximately 125% of the federal poverty guideline, you're earning about $15,000 a year. The next option is that the petitioner just pay for the proceedings. The defendant can pay for the proceedings. So you're going to want to check that you want to file an IFP and the defendant should be cast with cost, or that the parties will share those costs. But even if you said that you decided to share the costs with the defendant, you're still going to be expected to pay at the time of filing. So if you're filing this with an IFP, the clerk will stamp it IFP filing. It will then go to the judge, and you'll find out at a later date whether or not that was accepted or rejected, denied. The next document is called a verification. This is just simply you take your state issued ID, photo ID to a notary who will sign it, and it confirms that you are, in fact, the individual who is seeking to establish custody, that you're the proper party, and then you're going to receive your order. So let me just clip through this. So we discussed the court fees and the informa pauperis. The verification, again, is just verifying your identity for the court. And then the order itself is going to give you the actual court date. Now, the next most important component of that order is ensuring that your defendant receives service. As a self-represented litigant, you're going to have to confirm that defendant received either personal or domiciliary service through the sheriff's office. You're going to provide the sheriff with the proper address for your defendant. They're going to make an attempt. This information for Orleans would be shared on the sheriff's website. You go to case inquiry and it will notify you whether or not the individual has been served prior to the hearing. If your defendant has not been served prior to that hearing date, you will have to reset the hearing and then attempt service again. So you may want to confirm where the defendant is residing. If there's another address, possibly work, you need to determine whether or not that is feasible for your service. Some work establishments do not accept service. If the defendant has counsel, maybe they've retained an attorney, you'll need to determine who that is. If they have several attempts and that individual cannot be served and you're being charged for every attempt, it's $30 in Orleans Parish for every attempt, you may need to proceed with a private process server. And there's some other ways in the law to serve someone who cannot be found for the hearings. If we cannot find the defendant, there may be other legal recourse, but again, we cannot advise you at the self-help resource centers, but we do our best to provide you guidance on how to proceed procedurally. We hope you found this video helpful. You're welcome to visit our website at probono-no.org. We have tabs for Self-Help Resource Center. The the web address is here. We thank you so much for your time, and we'll be producing additional videos on what to expect at the next phase, which is the hearing and the actual judgment for custody. Thank you so much. Bye-bye.